y'all know I'm usually rarely on this time of night, right? It's only after 7, but yeah, y'all don't see me doing new videos like this time. But I just got finished watching the emergency motion hearing in regards to this Fani Willis situation. And you mean to tell me that these people are trying to depose Fani Willis and they haven't even deposed the husband? I thought the divorce was final, but based on the hearing that I just watched, the divorce isn't final. But they haven't been together. She moved to a different state. But anyway, I don't want to get into those weeds. Fani Willis won her emergency motion. Here's the news report.
Today, a judge handed Fulton District Attorney Fani Willis a temporary win amidst allegations she had a romantic relationship with the special prosecutor. The person we're talking about here is Nathan Wade. He was hired to lead the election interference case against former President Donald Trump and several others. Investigative reporter Zach Merchant was in the courtroom today. He's joining us live now. Zach, what is the latest with this case?
She said we prosecutors will reach out. The big issue was whether Fulton County District Attorney Fani Willis would have to sit for a deposition tomorrow in Special Prosecutor Nathan Wade's ongoing divorce case. And today, a judge ruled, at least for now, that answer is no. Attorneys for Nathan Wade's estranged wife, Joycelyn, were seeking to enforce a subpoena compelling Willis to sit for that deposition. Willis's attorneys today tried to convince the judge to block it. Cobb County Superior Court Judge Henry Thompson ultimately did not make a final decision today, saying he needed more information before making an ultimate decision. But because the deposition was scheduled for tomorrow morning, he issued a temporary stay, basically an extension, allowing Willis to skip the deposition for now. In her motion seeking to block the subpoena, Willis had accused Joycelyn Wade of trying to use the legal process to harass the district attorney. After the hearing, her lawyer, Andrea Hastings, responded.
It wouldn't matter who she is and what position she holds. If she's having an affair with my client's husband and he's spending my client's money on that relationship, I'm going to find out about it.
And that deposition was not the only issue addressed in court today. Coming up at 6, we'll tell you what else happened right here in the Cobb County Courthouse.
Her client's husband, who said 2 years ago in their divorce documents that the marriage was irretrievably broken. Okay, you know what? Whatever. Anywho, when you match these dates to this date to when that one filed versus when this one filed, it certainly screams, yeah, we're trying to delay, we're trying to embarrass Fani Willis. Yeah, and while we're at it, we're trying to be a thorn in the ex-husband's side. Meanwhile, the reason why they're getting the divorce is because the husband found out that the wife cheated on him with one of his good friends. Anywho, I'll leave you with what the judge had to say during the hearing, and I'll see y'all tomorrow.
Well, both sides have good points. Ms. Hastings, I agree with. The irretrievably broken does not prohibit you from presenting evidence of adultery if that's relevant to equitable division of marital estate or marital assets. So I agree with you there. You're not prohibited from getting into that. However, I also agree with Mr. Axon that OCGA 91126.1 is there for a reason. And the key part to me is whether the proposed opponent lacks unique personal knowledge or has unique personal knowledge of a matter that's relevant to the subject matter. And under D1 of that statute, that the party seeking the deposition has exhausted other reasonable means of discovery and found such discovery to be inadequate. So really, I'm not in a position where I have sufficient information to make a finding either way of whether the proposed opponent has unique knowledge. Because this case is a divorce, and I understand there are children, but they have attained the age of majority. So we don't have to deal with child custody or visitation or child support or who's going to have the final say on medical or educational or religious issues. So that takes out a large portion of what people normally fight over in divorces. It seems to me, you can correct me if I'm wrong, that what we have here is a math problem. Equitable division of the marital assets after determining what they actually are, alimony, and attorney's fees. That's a mathematical equation that we need to solve. The solution will be a number, or three numbers, but the numbers will be expressed in dollars and cents. And without Mr. Wade having been deposed yet or given sworn testimony yet, I'll note for the record we have a hearing set for 9 days away where sworn testimony can be presented. Without me knowing what Mr. Wade would say, it seems to me that Mr. Wade would be the first and best source of information on what his income has been and how he's been spending it, and that he would have first-hand knowledge of whether he's engaged in an extramarital affair. Only after I hear what Mr. Wade has to say do I think I can make a determination of whether the proposed opponent has any unique knowledge about these issues. Because once again, this is a math problem, and that we need to find a solution to. So, with all that being said, I'm not prepared, Mr. Axum, to grant your protective order, but since the deposition is set for tomorrow and our first evidentiary hearing is set for the 31st, I will issue a stay. And I will stay the deposition until I'm in a better position to make a determination of whether the proposed opponent would have any unique knowledge, unique being the key word there, that is not possessed by Mr. Wade himself. Now, if there's not anything else, I need to seat a jury in a criminal case.